means 7.5 million children, because it's 10 grades, each of them are 750,000 children. So the scale of the problem is, with respect, enormous. We're talking about 7.5 million children who on the 8th of June did not receive the meals to which they were entitled. Now, the respondents say that they will resume meals for these 7.5 million children, but they say they'll do it in accordance with what they call context-specific plans. It's not altogether clear what that means. They say they will do so on a phased-in basis, and they say they will do so gradually. And the evidence before your ladyship shows, and I'll take your ladyship there in due course, that last week on the 23rd of June, huge numbers of those 7.5 million children were still not receiving their daily meal. And I'll go to that evidence in due course. So if one assumes very optimistically that of those 7.5 million children, half were in fact receiving meals by 23rd of June, by last week, the evidence suggests that it's much less than that, but let's assume optimistically that half of the 7.5 million received the meals to which they were entitled. What that means is that between 3 and 4 million children are still being deprived of their school meal every day. That's the size of the problem that your ladyship has placed before her. So what this case is about is that between 3 and 4 million children are deprived of the school meal to which they're entitled, and they go hungry every day, and every day that this continues. This is despite the fact that it's common cause that the program is fully funded. It's common cause that funds have been allocated for this, and there's no defense raised that this is going to cost too much. The money is there. But as we stand here or sit here today, there is absolutely no guarantee as to when these children will receive the daily meals to which they're entitled. And our learned friends accept, for purposes of this case, that they're entitled to those meals as a matter of constitutional right under the Constitution. And that, with respect, is what this case is about. If I can then turn to the facts in more detail. As your ladyship will be aware, this program was instituted in 1994, and it now feeds 9 million learners every day, every school day. In March 2020, all the schools were closed as a result of the national lockdown, and as a result, the program was suspended. And what happened is, the consequence of that is described by Professor Jeremy Seekings of the University of Cape Town in his expert report and affidavit. I'm not going to take your ladyship there. It's NM6 at page 00691. It is summarized in the founding affidavit, and I would like to take your ladyship there. Can I ask you that you be invited to 00626?
I'm there.
Thank you, my lady. At the foot of that page, paragraph 40, the founding affidavit says the following: the Seeking Report notes that COVID-19 and ensuing lockdowns across the globe have exacerbated unemployment and poverty, and that even conservative estimates of the size of the global contraction would push an estimated 34 million people, mostly in Africa, below the extreme poverty line. Can I just say, our heads of argument missummarize that. We suggest they can be read as suggesting it's 34 million in South Africa. It's 34 million globally. Professor Seekings explains the purpose of his report is to provide an analysis of the efficacy and reach of the government's emergency expansion of social protection during the lockdown. In paragraph 41, the Seekings report notes that while the emergency unemployment insurance reform has provided some support for formerly employed workers, and the supplements to existing social grants, though less than initially anticipated, have reached many poor households, the failure to deliver the new emergency COVID-19 grant and the net cutback in feeding programs, now that's this program, means that many poor households face grave poverty. The report states many children in these households face the risk of malnutrition, with possibly long-term damage to their health. Now that's not in dispute, my lady. That's the consequence of what has happened and what is continuing to happen. And then paragraph 42, the Seekings report points out, deals with the grants which have been made. He deals, paragraph 46 on page 00629 with the calculations. Could we just go there to 00629?
I'm there.
Thank you, milady. And at 00629, he points out that, in summary, the government, the various feeding schemes provided 200 million meals over 9 weeks. That this program alone, this suspended program, would have provided double that amount over that same period. And that's a program that's directed specifically at children, whereas the 200 million are for all the members of the household. So the impact on the children is patently dramatic. None of that, as your ladyship knows, is in dispute. His findings of Professor Seekings, which are at a macro level, are confirmed by the evidence before this court, which is given by people who are affected by what has happened. That is, by parents, by caregivers, and by children. And I'll take your ladyship there in due course. But your ladyship will be aware that there is detailed evidence by a number of people who are affected. If I can just give your ladyship the reference, it's pages 006127 to 006224. And I'll refer to some of that in my later submissions. What I will say is that it makes very painful reading. The simple fact is undeniable and is not denied that the suspension of the program has had the result that millions of children went hungry because they did not receive the daily meal they had previously received under the program, and that was the position in the initial period of lockdown when the schools were all closed. But then at that stage, we were talking of 9 million children who didn't receive those meals. Plans were then made to reopen the schools and at the same time to resume the program. And during this period, the government repeatedly stated that when the schools were reopened, the program would be resumed for all. They stated that this would apply to all schools and to not only to grade 7 and grade 12 learners who would be the first to return to school. Your ladyship will have seen those statements. If I can just go to the heads of argument, it may be convenient. It's section 052, page 11. Is your ladyship there? Thank you, my lady. Thank you, my lady. If your ladyship would then look at top of the page, just below that, paragraph 21.3, on the 11th of May, the Council of Education Ministers, now that's all of the respondents effectively, resolved that when schools reopened, the NSNP would be extended to all learners, not only to the grade 7 learners and the grade 12 learners, whose classes would be the first to return to school. That was repeated by the Minister, paragraph 21.4 on the 19th of May. It was repeated by the Director General, 21.5 on the 19th of May. It was repeated by the Chief Director on the 21st of May. Over the page, at paragraph 21.7, it was repeated by the department when it issued the media statement. And so there were these repeated statements and promises that when the schools reopened, the program would be resumed for all. And then, as your ladyship is also aware, that the Council of Education Ministers ultimately decided that the grade 7 and 12 learners would return on the 8th of June. That was when the schools reopened. But so the position up till that moment was consistent and unequivocal. When the schools reopened, the NSNP would resume for all learners. But on the 1st of June, the minister made a sudden about turn. And the fullest version is in the founding affidavit. Can I ask that you be invited to section 006, page 49. It's paragraph 95 of the founding affidavit. At the foot of that page.
Please repeat the page number.
006, page 49.
I'm there.
Thank you, my lady. Then at the foot of the page, I'd like to read in full what the minister said, because that's quoted, parts of it are quoted in elsewhere, but this is in the heads of argument. This is the fullest statement we have. What the minister said was, we need to urgently start providing nutrition, not only to learners that have returned. So for those learners that are returning, there are plans. We've trained the school nutrition team that prepares food on new and different ways of preparing under the health requirements, so that we will provide nutrition to the grades that are phased in. We would have wished also even to provide nutrition for grades that we have not phased in. But I'd requested the sector and the MECs to say, maybe we need to wait a little, get ourselves to acclimatize to the new environment, manage that which we are still struggling to get right before we can introduce new programs. So there is intention to start the nutrition, but we just really need to find our feet in this new environment, be comfortable that we are able to manage this new environment before we find a new environment we find ourselves in, before we can get into more programs, but we have intentions to do that. So the minister's statement was unequivocal. Plans had been made for those learners who were returning. Those would be implemented. And there was an intention to provide for the rest, but that would be phased in over time gradually. And what then happened when that was announced, when that sudden about turn took place, the applicant's attorney immediately wrote to the minister and also to the other respondents. And your ladyship will find that if the court can be taken there, it's 006, page 211, page 311, I beg your pardon. 006, page 311. It's NM 47 to the founding affidavit.
I have it.
Thank you, my lady. Now, this is a letter which is sent, a letter of demand which is sent to the minister the day after she made her sudden about turn. And if I can just take your ladyship to various paragraphs, over the page, paragraph 5, this is at page 312.
Yes, I'm there.
This is what the letter says. The minister appears, therefore, to have backtracked on her initial statement, as well as the public undertaking by the Director General to provide food to all learners ordinarily eligible for the NSNP as soon as schools reopen. In doing so, she is irrationally, unreasonably, and unlawfully limiting access to basic nutrition to millions of learners across the country. Then on the next page, paragraph 9, this is page 313.
Yes.
The letter says, in the circumstances, there is no legitimate reason to continue to suspend the complete rollout of the NSNP to all grades and for all eligible learners beyond the first day on which schools are open to any learners at this stage, 8 June 2012, paragraph 10. Furthermore, the continued suspension of the NSNP is a regressive measure in violation of various rights of learners, including the right to basic nutrition in terms of section 28(1)(c) of the Constitution. Paragraph 11, we are instructed to make application to court for relief should the DBE fail to A, roll out the NSNP to eligible learners in all grades on the first day on which schools are open to any learners, and B, direct provinces to comply with this commitment. In paragraph 12, we request a response to this letter by the close of business on Thursday, 4 June 2020. So there's the issue squarely identified in the letter of demand. The minister replied to that letter in a letter dated 6 June. Sometimes it's called the 7th of June letter because I think it was sent a day later. If your ladyship will go to, can be taken to page 006 316, that's NM 48. Your ladyship will find the minister's answer.
I'm there.
Thank you, my lady. Now, this is the letter on which the respondents rely for their defense in this application. It's a letter from the Minister to Equal Education Law Centre. Paragraph 2 says, it refers to the letter of the 2nd of June, which said, you've announced that you're not going to resume for everybody. We say you have to. And her answer is the following, paragraph 2. I have noted content of your letter and wish to reiterate that when schools reopen, meals for National School Nutrition Program will be provided to learners in a phased-in approach. This will not only be for the learners who are returning. Provinces, third paragraph, provinces have context-specific plans to reach learners not yet in school. This, which includes staggered school hours or days, which will include the provision of meals. We further collaborate with the Department of Social Development and its nutrition centers to reach the learners in families, households not yet in schools. So that's what's being done with them. The latter model has proved to be challenging as learners from far-flung areas who regularly use scholar transport to come to school present a challenge that provinces are attending to. This, therefore, will take a gradual process to acclimatize with the new environment. So the minister doesn't say, oh no, we are going to provide everybody from the 8th of June. To the contrary, she confirms that they're not. And she says it will be done gradually on a phased-in basis within context-specific plans. So there, the issue is joined. The applicant's attorneys write again to the minister in an attempt to resolve this matter without litigation. And can I say, milady, that there's a complaint about a barrage of letters. There's not a barrage of letters. There are letters sent in an attempt to resolve this matter without litigation. That's what responsible parties do. But on the 8th of June, the applicant's attorneys write, it's page 006319. And is your ladyship there?
I'm there.
Thank you, milady. It's a letter to the minister and to the MECs, the present respondents. Paragraph 3 says, it appears that the minister has chosen to leave it to each province to decide whether, when, and how to roll out the NSNP to learners, including those who are not yet in school. She states that provinces have context-specific plans to reach those learners not yet in school. I'll show your ladyship later the letter which is received in reply. It's received a bit later, but there's that's not denied, that it was left to the provinces to decide when and where, whether, when, and how. In paragraph 4, they say, we request from each MEC a copy of the province's plan to reach learners not yet in school, to which the minister refers. Those are the context-specific plans. And then over the page, on page 8, page 006320, para 8.
Yes, I'm there.
The demand is repeated and expanded. Paragraph 8, given that the NSNP is intended to ensure that learners are provided with basic nutrition to enable them to concentrate and learn, the failure to roll out the NSNP to learners, encouraged to continue learning at home, is a violation to their rights to nutrition and basic education. The minister is obliged to ensure that the NSNP is provided to all learners immediately, or where it is not done immediately, to design and implement reasonable programs effectively, diligently, and without delay. So again, it's squarely laid as to what the case is about. In paragraph 21, so what the minister, as I'll show your ladyship shortly, didn't respond until about 10 or 12 days later, I think 10 days later. But what is not in dispute is that when the schools reopened on the 8th of June, only children in grades 7 and grade 12 were provided with meals. There's no suggestion that it was rolled out to anybody at that stage. To the contrary, the contrary was the purpose. So 2 days later, the applicants then launched this application on the 12th of June. And the founding affidavit sets out at the very outset what the cause of complaint is and what is the cause of action. Can I ask your ladyship to be taken to 006, page 13?
I'm there.
Your ladyship will see this is the founding affidavit. It's page 2 of the founding affidavit. It's right at the very outset, background to this application. And the deponent says, Ms. Madube Dube says, this is an application for an order. This is an application for an order requiring the Department of Basic Education and the Provincial Departments of Education to provide a daily meal under the National School Nutrition Program to all learners who qualify in terms of that program. Paragraph 4, if I can just go to the last point of last paragraph of last sentence of that paragraph. The impact of the suspension of the NSNP has for many learners and their parents been devastating, as described in the supporting affidavits NM9 to NM29. And the statement that the impact of the suspension has been devastating is also not disputed. Then in paragraph 5, she says, during the period of school closure, learners have been encouraged to continue their education at home through the use of broadcast and online services, online resources. They have, however, not received the daily benefit of the NSNP. Paragraph 6, 7, and 8 recites the minister's announcement that there wouldn't be a full resumption and the failure to resume. And then paragraph 9, here comes the critical passage. Paragraph 9, a failure of the respondents to roll out the NSNP to all qualifying learners, or even to produce a plan or program for doing so, is a retrogressive measure that violates the following rights and breaches the following obligations. 9.1, the right of every child to basic nutrition. 9.2, the right of every child to basic education. 9.3, the right to equality. 9.4, the right to public administration in line with the values and principles in section 195 of the Constitution. Paragraph 10 says, no lawful justification has been given for the violation of limitation of these rights. And paragraph 11, given the importance of these rights and obligations, the ongoing violation and the consequences of the violation, the applicants bring this application on an urgent basis. That's the cause of action, the failure to provide. And then that is reinforced by a continuing failure to provide. And then that is reinforced in the notice of motion. If I can ask your ladyship to be taken there to page 0063.
And there?
So paragraph 2 of the notice of motion asks for a declaration of the entitlement of all qualifying learners, regardless of whether they've resumed classes at their respective schools, to receive a daily meal as provided under the NSNP. So the first is the declaration of the right. Paragraph 3 is the declaration that the first respondent, the minister, is under duty to ensure that the NSNP provides a daily meal. That's the duty which is alleged. Paragraph 4, the declaration that the minister is in breach of that duty. What duty? The duty to provide. Paragraph 5, the remedial order or mandatory order. The minister is ordered without delay to ensure that the NSNP is implemented in such a manner that it provides a daily meal to all qualifying learners to ensure the proper exercise of their rights, whether they are attending school or studying away from school. So the notice of motion is a declaration of the rights of the learners, a declaration of the obligation of the minister to ensure that the program provides, a declaration that the minister is in breach of her duty to ensure that it provides, and an order on the minister to ensure that the program provides. Then paragraphs 6, 7, and 8 are identical, except that they refer to the MECs. And then from paragraph 9 onwards, there is the structural relief which we seek in order to make sure that the minister and the MECs actually comply with the order. So that, my lady, is what this case has been about from the very beginning, from the moment it's what was case was about before the litigation was started. That's what the correspondence says. And it's what the case was about when the litigation was started. In the founding affidavit and the notice of motion, it could hardly be clearer. The respondent's defense we submit, as set out in the heads of argument and also in the affidavits, is with respect bizarre, because they do not allege that they have resumed providing meals to all qualifying learners. The defense is simply that they haven't refused to provide meals to all qualifying learners because they have said, one day we will do so. And that's the defense to this application. But that's not the issue. The issue is not whether one day they will do so. The issue is whether they will do so today and continue doing so tomorrow. And that's set out. I've shown your ladyship in the founding affidavit. I'm not going to waste your ladyship's time by going back there. That was the complaint and is the complaint. So what the case is about the failure to provide. And the evidence is clear that there was a failure to provide on the 8th of June, and there is a continuing failure to provide. And we submit that the facts are quite plain. A demand was made that the respondents resume meals to all qualifying learners on the 8th of June. The respondents, that's the first part. Second, the respondents did not comply with this demand on the 8th of June. They didn't supply to all qualifying learners. And thirdly, they've still not complied with the demand. That's our case. The respondents pin their whole defense apparently on the fact that in some parts of the founding affidavit, the word refuse is used. And they say that that's what the case is about, and they haven't refused because they are going to do it one day. We say that's not what the case is about. The case is about a past and current and continuing failure to provide. It's clear from the passages in the notice of motion, in the founding affidavit, which I've read, your ladyship. It's clear from the notice of motion. The notice of motion doesn't ask for an order that they undertake to provide one day. It asks for an order that they provide now. That's what the case is about. It's true that the founding affidavit refers at some points to refusal. Can I show your ladyship just one of those which identifies what the refusal is, what the nature of the refusal is? Could we go to page 006, page 67? Thank you, my lady. Your ladyship is now muted. I don't know.
Yeah, I apologize. The one clock went off. So but I am there. Thank you.
Thank you, my lady. Paragraph 144 identifies the nature of this refusal. It says, finally, the refusal by the respondents to ensure that all learners are fed as soon as schools reopen is inconsistent with section 195 of the Constitution. And then paragraph 145, these are paragraphs on which our learned friends rely. Paragraph 145 says the refusal to provide meals to all learners is inconsistent with section 195. If you ask which refusal, it's obviously the refusal in the previous paragraph to provide to everybody when the schools reopened. Paragraph 146, the refusal to resume the NSNP for all learners amounts to an unreasonable and unjustifiable limitation of the rights. Which refusal? The refusal to provide to everybody when the schools reopened. And so, in fact, to the extent that our learned friends make anything of the word refusal in some parts, there was in fact a refusal, because there was a demand made, reinstate the program for everybody, or resume the program for everybody. And there was a refusal to do so. They said, we'll do it one day when we're ready. But the demand was to do it now. And there was a refusal to do it now. There was a refusal to do it on the 8th of June, and there was a refusal to do it on a continuing basis. The respondent's answer is one will, your ladyship has seen the NM 48. I won't take your ladyship back there, the minister's letter. The answer is we will do it one day, gradually, on a phased-in basis, in accordance with context-specific plans. But there is no denial of the failure to roll out to all learners. And can I just take your ladyship to two letters which demonstrate that? NM 49, it's page 006318. That's the letter I showed your ladyship a moment ago, the letter of the 8th of June.
I'm there. I'm there.
The ladyship will recall paragraph 3. It says, it appears the minister has chosen to leave it to each province to decide whether, when and how to roll out learners, including those not yet in school. And the following page, paragraph 8, refers to the failure to roll out the NSNP to learners encouraged to learning at home as a violation of their rights. The minister is obliged to ensure the NSNP is provided to all learners immediately. Well, so that was the demand which was made. And the answer your ladyship will find at page 011, page 287.
I'm there.
Your ladyship will see that's the response. It's called response without prejudice. I don't know why that is, but it's put in by the respondent. So if there ever was any privilege, it's been abandoned. It says your letter dated 8 June 2020 refers. So this is a response to the letter I've just shown your ladyship saying you have to resume now. And there's various responses about when the paragraph 1, the total number of learners provided with meals is available, not disaggregated. I trust the MECs will give it to you. Well, they didn't. Secondly, the number that are currently provided will be available at the end of the quarter. And thirdly, over the page 288, credible data on household beneficiaries receiving food parcels as referred to in my response letter of 11 May 2020 is not yet available to us. And last paragraph, I trust that you will be patient and supportive of the department. So there's no suggestion in that letter we have done it. No, neither is there any commitment as to when it will be done. Neither is there even a denial that it's being left to the provinces to decide when, where, and to whom it is going to be returned. Your ladyship will remember that in the previous letter, where the attorney said it appears the minister has chosen to leave it to each province to decide whether, when, and how to roll out the NSNP to learners, including those who are not yet in school. There's no denial of that in the letter. That is, in fact, what has happened. And so if you want to look for conduct which meets the word refusal, there's the refusal, continuing refusal. There's a refusal to do what was demanded, and that continues. And we say, milady, it's impossible for the respondents honestly to say, they can't honestly say that they thought that what the applicants wanted was a promise to resume the program one day. Because that's what their case is. We haven't refused to produce it, to resume it one day. They can't possibly have honestly thought that all that was asked of them was a promise to resume it one day at a time determined by each province when they thought fit. It was a demand. It was not a demand. It was the answer, we'll roll it out to all learners one day and we'll decide when that will be. There's no answer to the demand which was made, and they can't possibly ever have honestly thought that's what the complaint was about. That would have been an absurd demand. So that brings us, and I'm coming to the end, my lady, to what actually happened. As your ladyship knows, the application was launched on the 12th of June this year. The parties agreed that the answering affidavit would be filed by the 22nd of June, 2020. And thereafter, the respondents suddenly sprung into action in an attempt to make something happen by the 22nd of June when they had to file their answering affidavits. And the smoking gun is RA 14, which is at page 012, page 146, volume 012, page 46. Now, I've given you the wrong reference to it. It's not 46, it's 146. Yeah. 012, page 146.
I'm there.
Now, this is an interesting letter. It's interesting also that the Director General has attached a vast array of letters and documents to his answering affidavit, but this one seems to have slipped his mind. He seems to have overlooked it. Thinks it's not important, apparently. This is what it says. It's a letter from the Director General to the head of the Department of Education in Gauteng, It's dated the 19th of June 2020. Now, this is just before the answering affidavit has to be filed. It's headed High Court application to feed all learners with effect from 22 June 2020. I don't know where that comes from, that the demand was 22 June 2020, but the respondents seem to have thought that's what it's about. Second paragraph. On Friday, 12 June 2020, the Department of Basic Education and the Provincial Education Departments were served with an application brought by Equal Education to challenge the decision of the Minister that the NSNP only be rolled out to learners who currently attend school grades 12 and 7 and be rolled out later to learners as they are phased in. The applicants requested the court to grant an order that the NSNP be rolled out to all learners, notwithstanding whether they are currently in school. Now, that's what they thought the case was about. The DG thought that was about. He didn't think that the applicants asked for an order that the respondents promise to do it one day, say that they will do it one day. They asked for an order that it be rolled out. The legal basis for the application is the right to nutrition and basic education. The applicants allege that these rights of learners are being infringed by the decision that the NSNP be phased in and not available immediately to all learners. Now the critical paragraph. At a virtual meeting on 14 June 2020, convened with your senior officials responsible for the NSNP, the plans in progress on feeding learners were presented. Thereafter, an agreement was reached to submit refined plans to resume feeding to all learners, including those not yet attending, using the various options which are set out there. Top of page 147, the plan required a list of all schools as per selected options by your province. Kindly be advised that in the court papers submitted to council, all provinces are required to start feeding all learners with effect from 22 June 2020. Any later dates will force the department to report to the court on a fortnightly basis. So that's what this was being taken for, to prevent that happening. Last paragraph, I wish to thank you for the positive response in submitting your final plans to resume feeding of all learners. Further give assurance of our support and guidance under the novel circumstances. So that's what the trigger was for the sudden burst of activity. The application was a sudden burst of activity aimed at the 22nd of June. And as your ladyship will have seen from the papers, there was then administrative chaos and confusion. I'm not going to take your ladyship there. It's summarized in our heads of argument, paragraphs 49 to 57. We summarize the chaos and confusion that followed. Circulars that had been withdrawn. In one province, a circular was issued, then the circular was withdrawn, then the withdrawal was withdrawn, and the original circular was reinstituted. In another province, although the chaos and confusion are manifest. In the Free State, SADTU, the teachers union, complained. They said, you've announced this on the 19th, Friday the 19th of June. It can't possibly be implemented on Monday the 22nd of June. It's utterly unrealistic. Steps have to be taken and so on. And there's, of course, the Gauteng letter, which your ladyship may recall, the Gauteng letter which refers to a meeting held that morning and says this is all going to be done from today. Transport is going to be arranged, notices are going to out, transparently no prospect of achieving it, because the meeting to decide that it was going to happen was on the very day in which it was supposed to happen, of which they said it was going to happen. And so there was chaos and confusion as a result of a desperate attempt to do something by the 22nd of June in order to avoid your ladyship making an order that the program must now be reinstituted. But what was done, as your ladyship will be aware, is that by the 22nd of June, what was produced were plans, some target dates, statements of what the plan is, what the target date is, or what should happen on that day. Not what's actually happening in the day, not action on the ground. And I do want to take your ladyship to what's in the heads of argument, which shows what actually happened just last week. It's volume 052, page 18. that's our heads of argument.
I'm there.
The ladyship will see what happened there. There was this extensive sample, extraordinary job was done by the applicants in one day to collect information from all around the country to find out what had actually happened in the light of the answering affidavit which had been filed the previous day. And this is what happened, paragraph 36. In the Limpopo province, 45 schools and 2 parents were contacted. None of the schools reported receiving NSNP meals to learners, providing NSNP meals to learners other than the grade 7 or 12 learners who'd returned. None of the schools reported having received any communication from the department that meals must be provided to all learners. 18 of the schools, that's 18 out of the 45, reported that the food delivered for the grade 7 or 12 learners was insufficient even to feed learners in those grades. Learners were being sent home early, they were being asked to bring extra food, they were being given smaller portions, or principals, educators, or school governing bodies were funding the purchase of additional food for the grade 7s and grade 12s. Over the page, paragraph 36.4, one of the schools is part of a pilot program in which the NSNP funds are transferred directly to schools. This school reported that it had received funds sufficient to feed all learners and would implement such feeding upon being given the go-ahead. As at 23 June 2020, the school had not been given the go-ahead. None of the other schools had plans to expand feeding. The 2 parents of learners in Limpopo reported that they were not aware that the NSNP had been reinstated for all the learners and that their children had not received any meals and they'd had no communication. And one then goes on. In KwaZulu-Natal, 9 schools and 10 parents were contacted. 5 of the schools were providing meals to all learners, 5 out of the 9, and 8 said we've received sufficient food for all learners, but some of them had no plan for the distribution of meals to learners who had not yet returned to class. The parents knew nothing. Paragraph 37.4 refers to Tobile Kumalo, who had deposed to an affidavit in the founding papers. She's a minor and she is the primary caregiver to her 2 siblings. She reported she wasn't aware of plans to reinstate the program for eligible learners. To date, her siblings had received no meals from their school. She didn't know when they would do so. Fikile Mabuza tells the same story. In Mpumalanga, 2 schools were contacted. One said we're feeding all, the other said we're feeding only grade 7. Eastern Cape, 15 schools. Only 3 schools reported they'd received sufficient funds to feed learners in all grades. Most received allocations only for 7 or 12. Over the page, paragraph 40, Gauteng, 13 parents and 2 equalizers were contacted. All 13 parents indicated their children had not received any meals from school and they'd received no communication. One equalizer said she'd received nothing, and one equalizer who's in grade 12 said she had received something. Paragraph 41 in the Western Cape, a mother of 2 children and 2 equalizers were contacted. The mother said the child hadn't received any meals. One equalizer said she hadn't, and one equalizer said that she had. Now that is the sum total. One could, obviously, the applicants couldn't deal with all the detail in every province in one day, but that's what actually happened. And so one comes back to the original complaint that I showed your ladyship in the founding affidavit. The complaint is, and the complaint remains, that the provision of food under this program has not been resumed by the respondents. And we submit that the factual allegations are clear. There's been no attempt to deny them. There's no allegation that it has been done and this is where and how it has been done. All your ladyship is told about is about target dates and plans and what should happen, not what has actually happened. And so what is the answer of the respondents? The answer is, but we haven't refused. We'll do so one day. We submit that's no answer. We submit that suggest that the respondents go and tell the children who are going hungry, don't worry, you've got no complaint because we are going to resume one day, and see what answer they get from them. Can I take your ladyship to the heads of argument again? It's volume 52, page 35.
I'm there.
Your ladyship will see there at paragraph 75, the pitiful story which is told by children and learners about what has happened to them. It makes truly painful reading. 75.1, learner EE7 and his sister survive on 500 rand a month, with which they can buy pap, but nothing else. Learner EE7 has now returned to school and is receiving meals, but his sister still not receiving them. Learner EE2 says her younger sister gave up trying to study from home because there's not enough money for food and data. EE2 feels guilty that as a grade 12 learner, she's now receiving an NSNP meal, but her younger sister and others in the area are still hungry. 75.3, learner EE7 describes her family fighting over bread and necessities, given the suspension of the NSNP and the food shortage at home. 75, Tobile Kumala, to whom I've referred, a 17-year-old child, who is the de facto caregiver for a family of 6 people, 2 of whom were learners who ordinarily receive a meal through the NSNP, said they'd not been able to buy food in June. And so it goes on. And the last one I'll read to your ladyship, 75.5, Nosipho Tembe. She is the primary caregiver for a family of 10, 4 of whom are learners, who usually receive a meal. She said the groceries that normally last for a month now last for only 3 weeks, and they struggle to afford to buy more. The answer of the respondents is, we haven't refused to provide meals to these children. Milady, one doesn't want to be, I'm careful not to use language which is offensive or which is overstated. But I have to say, and I don't say it lightly, that the minister and the MECs are playing games with the court. And they're playing games with the children and their parents by putting up this sort of defense. The minister and the MEC's refusal simply refused to engage with the substance of the case against them, as is set out in the founding affidavit of the notice of motion. Instead of attempting to justify their conduct, they raise a semantic defense based on the use of the word refuse in some parts of the affidavit. Meanwhile, millions of children go hungry every day. And I have to say it, and again, I do not say it lightly, it is cynical and it is callous. And it's time, with respect, to put an end to it. It demonstrates a failure to understand the principle of accountability in section 195 of the Constitution. When a challenge like this is raised, to try to duck it by saying, oh, we didn't refuse, that's a failure to understand the obligation of accountability in section 195. We say, with respect, it's time to put a stop to this and to put a stop to millions of children going hungry unnecessarily every day. Hunger is a problem in our country. Poverty is a problem in our country. This is about a program which can and used to do something about that. There's a failure to implement it. And so, my lady, those are the facts of the case. My learned friend, Mr. Tukaitobi, will deal with the legal consequences and with the question of remedy, unless there are any questions your ladyship has for me.
No, thank you very much, Mr. Bandlinder. Thank you, Mr. Mekatubi.
Thank you, my lady. If I might then start precisely where my learned leader has left the debate. The leadership has already asked our learned friends to explain what precisely their defense is in relation to the rights. The answer that your leadership got, if I understand it properly, is that although they don't deny that the learners do in fact have the rights as we contend, what they dispute is the scope specifically of the right to education. What they claim is that the right to education does not include nutrition. The explanation why they claim that it does not include nutrition is because they say that nutrition and food are provided for expressly in different parts of the Constitution. Now, your leadership can safely reject that defense. Why? Firstly, if your leadership has regard to the government's own papers at 01175, if I can take your leadership there. It's the answering affidavit at 01175 at paragraph 63 of their own.
I am there, thank you.
Yes, thank you, my lady. This is what they say. They say, I differ from the ex post facto rationalization by the applicants in this paragraph. And then they explain why. They say the National Schools Nutrition Program was introduced for the main purpose, the underlying main purpose of increasing the ability to learn and therefore promote the right to basic education as provided for in section 29(1)(a) of the Constitution. So their pleaded case conflicts with the argument they are now advancing that the nutrition program should not be seen as a composite element of section 29(1)(a) of the Constitution because it is provided for elsewhere in the Constitution. So that's the reason number one that your ladyship can safely reject the defense that is advanced. But your ladyship can reject this also on the law in any event. We have shown in our heads of argument, particularly by reference to the two judgments, the one by Justice Colapen in the Section 27 case and the Court of Appeal judgment in Basic Education for All versus Minister of Education, which are referred to at paragraph 130 of our heads of argument. And this is at 052. 52 at paragraph 128 and 130. The question that the court had to answer there was, how do you define the scope of the right to education? And this takes place in the context of that case of textbooks. The government in that case had somehow denied that textbooks are part and parcel of the right to education, which is an odd defense. And the court, in deciding that question, said they should have regard to policy statements, and that is at paragraph 127 of our heads, and where Justice Colapen says, the answer to this question, in my view, can be found easily in the policy statements of the state in respect of textbooks and their relationship to giving effect to the right to basic education. That proposition was endorsed by the Supreme Court of Appeal in Minister of Basic Education versus Basic Education for All at paragraph 130. And in the underlined portion where the Justice Nafsa says, the content of the section 29(1)(a) right is also determined in DBE's action plan for 2014, which is towards the realization of schooling in 2025. So what we know from the two judgments is that the policy statements announced publicly by the department can be instructive in defining the scope of the right to education. In this case, we rely on three primary instruments that have been announced by the government itself. Firstly, we rely on the Division of Revenue Bill 3 of 2020. Mr. Badlander has already referred your ladyship to that bill, but that bill makes it clear that the reason why money is allocated for school nutrition is to improve access to education. So National Assembly, although it has not yet been passed by the NCOP, but the point is that the position of the National Assembly is that the money should be allocated in order to improve access to education. Secondly, we have referred to the national policy guideline issued by the government of 2009, which the government confirms is still operative. And it also makes it clear that its intention is to provide meals to the most needy learners to help them remain alert and receptive during lessons. And then the third instrument is the 5-year strategic plan of 2015-2016 to 2019-2020, which also makes it clear that the nutrition program is used to alleviate poverty, which is one goal, but also it says it is also specifically initiated to uphold the rights of children to basic education, to basic food and education. That is at paragraph 136 of our heads of argument. So state policy is clear that nutrition is provided in order to provide access to education. The second reason your leadership can safely reject the defense is by examining the content of the right itself, independent of the government's policy position. We deal with that from paragraph 137 to 144 of our heads of argument. What we point out is that self-evidently, the right itself, the right of access to a basic education, is a right about self-development. But self-development is much more important in a country like South Africa, which is characterized by differences in race and differences in class. And in South Africa, where many learners are unable to access food, not because of choice, but because of historical reasons, the government accepts that it is providing food in order to fulfill Section 9, subsection 2 of the Constitution. But what it appears to contend is that it can discontinue the program and it can reinstate it at a time and place determined by itself. But if the government is allowed to adopt that attitude, it would mean that the rights to equality of learners are also violated. Because if it is true that this provision of meals is part and parcel of Section 9.2, the judgment in Van Heerden makes it clear that Section 9.2 is integral or central to the realization of the right to equality. So once food is provided, it may not be taken away without violating the right to equality. And of course, although one does not want to place race at the center, but we cannot avoid the inevitable conclusion that the vast majority, I would even say probably 99.9% of learners who qualify in these quintiles 1, 2, and 3 are Black learners, particularly African learners, who are not only Black, but also in poor schools in the townships and poor schools in the rural areas. And it is especially important that they are assisted by the government to have food in order to pay attention in class. And we deal with that vulnerability at 138 and 139. And then thirdly, under this topic, we also say that on the common cause facts, the reason why this program was extended to these learners in particular is because the primary caregivers and the parents are simply unable to provide adequate food for their own children, which itself is a legacy of the past. So your leadership has a very odd scenario where the learners are trapped between parents who are unable to feed them and a government which denies that the learners have a right of access to education, which includes provision of meals. In those circumstances, we would say that the injunction in Section 39(1) of the Constitution should come into effect. What that injunction asks of your leadership is when you construe the Constitution, particularly Section 29, you should do so to promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. We make the point, oh, Jesus.
Is your computer playing games with you?
It is, my lady. I'm sorry. The screen just went blank. Thank you, my lady. I think I've now come back.
Okay.
So, my lady, we make the point that there is an injunction in Section 39(1) that when you construe the rights in Section 29 of the Constitution, you should do so in a way that promotes the values that underlie an open and democratic society. But not just any open and democratic society, but one that is based on human dignity, equality, and freedom. And we place emphasis on human dignity, and we ask of your leadership to take into account that nothing can be more undignified than starvation. And in circumstances such as this, where the state either argues that there is no right at all, which is part and parcel of the right to education, Alternatively, if the right exists, it will be provided for in some future date. In those circumstances, it is inevitable that children will be driven to starvation. And this application at its core is to prevent the almost inevitable starvation of children. Mr. Butler has set out to your leadership the facts in detail. I just want to highlight from his address one element, which is the most striking element. Firstly, food was taken away from these learners when the lockdown was first announced in March. Overnight, food was taken away. The one meal that they were guaranteed was taken away. Secondly, the government said it was going to reinstate these meals on its own version to everybody when the schools reopen. The schools were meant to reopen on the 1st of June. They did not reopen. They reopened on the 8th of June. On the common cause facts, even the promise that was made by the state that food would be distributed to everybody on the 8th of June was not fulfilled. The government subsequently said that food would be distributed by the 22nd of June. It was not distributed on the common cause facts. As we speak today, no one has any clue about whether or not the learners that are mentioned in the address by Mr. Butler are going to get food today or tomorrow. This is the most striking feature of this case, is that although we are hell-bent in arguing the case based on sophistry, the bottom line is that we have these children who still have not received food since, my lady, since March 2020, when the program was suddenly discontinued overnight. So in circumstances such as that, we would submit to your leadership that your leadership should not buy the idea that the right in section 29 does not include nutrition. It is a component of the right that learners should be fed. They cannot study on an empty stomach. Final point to be made about this is that ultimately, and as the Center for Child Law makes clear, ultimately, these rights do not necessarily allow for a rigid separation. These are interdependent and indivisible rights. The right to nutrition and the right to education are interdependent and they are indivisible. So that's insofar as the argument that we think is the sole argument remaining of the state, because when your leadership asked them what they say, the only point they made this morning is that the right to education does not include nutrition because nutrition has a specific provision. We would ask your leadership to reject the argument and to find that the right to education does in fact include the right of access to nutrition in appropriate circumstances. In any event, there is a further problem that the state faces, which is under section 7(2) of the Constitution, they are obligated, among other things, to respect and protect the rights that are contained in the Bill of Rights. The way that right has been construed by the Constitutional Court in several judgments that we have cited, including the Law Society judgment, is that this imposes a duty on the state to respect existing access. So we are not asking for additional rights, we are not asking for additional expansion. What we are asking for your leadership is simply to respect the existing access of the right. So the existing access of the right was that 9 million children were receiving a meal a day. That cannot be discontinued by the state at will. Nor, as Mr. Butler points out, can it be postponed that one day you will get it and you can sleep hungry tonight because one day we will feed you. The rights in section 7(2) make clear that if you are already a recipient of a right that is provided for in the Constitution, it may not be discontinued, which is precisely the scenario that we are faced with today. So I would ask your leadership that insofar as the sole remaining argument is concerned, it should be rejected and your leadership should find that the right includes the right to nutrition. That makes the job much easier because we can then move to the question of relief. Mr. Butler has already made submissions in relation to relief. I want to emphasize two elements. One is the declaratory relief that we ask for. Second is the supervisory order that we ask for. Your leadership will remember that our learned friends rely on the rail commuters case when they contest our submission that we are entitled not only to a declaratory order, but also to a supervisory order. Particularly, they rely on paragraph 107 of that judgment. I want to just take your leadership to that case. It is item 20 of our bundle of authorities. I'm not sure if these were uploaded on case lines because I don't see that they are numbered on case lines. But it's item 20 of the bundle of authorities that was circulated. And paragraph 109 of that judgment, which is referred to in the heads of argument by our learned friend. This is what it says, if I may read it out. It says, in this case, Metro Rail and the Commuter Corporation denied in error that they bore obligations to protect the security of rail commuters. Given the importance of that obligation in the context of public rail commuter services, it is important that this court issues a declaratory order to that effect. So if we can stop there, I'll come back in a moment to the structural order. The Constitutional Court makes plain at paragraph 109 of rail commuters that where a state entity denies in error that it bears an obligation, in those circumstances, it becomes especially important for the court to issue a declaratory order. Now, the reason the court says so is because in paragraph 107, it has already outlined why a declaratory order is important. And it says in paragraph 107, it is quite clear that before it makes a declaratory order, a court must consider all relevant circumstances. A declaratory order is a flexible remedy which can assist in clarifying legal and constitutional obligations in a manner which promotes the protection and enforcement of our Constitution and its values. Now, your leadership has read the papers. You would have seen that the state denied the right of access to education on the same basis that is being argued today. It also denied the right of basic nutrition on the basis that that obligation falls primarily on parents and only alternatively or secondarily on the state. Today, the state says it no longer denies the rights, but the equivocation that is contained in the answering affidavit should be sufficient to warrant a declaratory order to be issued, because what we have is precisely what happened in rail commuters, a state that has denied in error its obligations towards the children. It claimed that there was no duty to provide nutrition because that was primarily a duty on parents. And it claimed that nutrition was not part and parcel of the right to education. If the state was wrong in relation to those claims, a declaratory order is important and should be issued. But a declaratory order is also important because it's mentioned in section 38, which provides that anyone listed in this section has the right to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. So it's got direct constitutional status that if a party can show a violation of rights, they are entitled to ask for a declaration that those rights have been violated. So much then for the declaration. Its constitutional basis is section 38. Its propriety in this case is made clear by rail commuters, particularly because there has been a denial. Even if subsequent to the denial, our learned friend says they no longer contest, the fact is that his client on oath has denied the right, and for that reason, he has to be set right. That then takes me to the question of the propriety of a supervisory order. It is hotly contested by our learned friends on a variety of reasons. The factual reasons have been put to bed by Mr. Badlinder. The textual basis for supervisory interdicts is section 172(1)b, particularly the phrase just and equitable. Your ladyship knows that you have the power to issue an order that is just and equitable. And justice and equity is by definition a flexible concept. But as in the case of Hoffman, it was pointed out in that case, which we cite at paragraph 152 and 153 of our heads of argument. One of its elements is that it is forward-looking, and one of its objects is to deter future violations. If we look at the facts of this case as narrated by my leader, it's clear that from March, certainly until the 22nd of June, the food that was cut off, or the supply of food that was cut off from these learners was not yet reinstated. No one can give any assurance that there will be no similar violations in the future, particularly given the flux of COVID-19. We may move back to level 5 at any stage, as this court recently found yesterday, actually, in the One Nation movement. And the same conditions that prevailed prior to the decision to terminate may be reinstated. But even at level 3, there are still practical problems in the delivery of food. So any remedy that your ladyship grants should also be a forward-looking remedy in order to deter future violations, particularly where one is dealing with an extremely vulnerable group of applicants. We've also referred to the Ngomane case of the Supreme Court of Appeal, and I will not refer to it in oral argument, and referred also to the EFF versus Speaker of National Assembly case and the Corruption Watch versus President. They all emphasize the point about the flexibility of the remedy and the justice and equity that is embedded in that remedy. So if it is so then that your ladyship has a proper textual constitutional basis to grant a structural relief whose purpose is forward-looking and is intended to deter future violations of the right, what then did we claim in the notice of motion? Your ladyship will see the notice of motion is divided into two: it's declaratory and supervisory order. And even in relation to those two elements, it's declaratory against the minister and supervisory against the minister, as well as the MECs. In relation to the minister, what we have asked in paragraphs 2, 3, 4, and 6, and 7 is the declaratory orders. So 2, 3, 4, 6, 7 are declaratory orders. Those are declaratory orders in relation to the MEC and the MECs rather, and the minister. And as the essence of those declaratory orders is a finding that every learner, regardless of whether they have resumed their classes at their respective schools, are entitled to receive a daily meal. Now, there is something important about that declaration, because our learned friends' case, as we understand it, is that as long as they've put up many pieces of paper which show that one day food will be given, this application does not get out of the starting blocks. And yet, if one looks at the nature of the declaration, it is declared that all qualifying learners, regardless of whether or not they have resumed classes at their respective schools, are entitled to receive a daily meal as provided for under the National School Nutrition Program. What that makes clear is that today, not tomorrow, not at some other unspecified future date, today, every learner is entitled to receive a daily meal. That's the declaration that we ask in unambiguous terms at paragraph 2. In paragraph 3, we say that the minister is under an obligation to fulfill the declaration in paragraph 2, that in order to exercise the right of learners to education and to enhance their learning capacity, they are to be provided. There is a constitutional duty to provide them with meals. And paragraph 4 is then a declaration that the minister has been in breach. And then paragraph 5 then says that they should put in place a plan, or in fact, they should implement the NSNP in a manner that it provides a daily meal to all qualifying learners to ensure that the proper exercise of the rights of learners to education and to enhance their learning capacity, whether they're attending school or studying away from school. Now, I should mention one point about paragraph 5, because what it says is, without delay, ensure that the NSNP is implemented in such a manner that it provides a daily meal to all qualifying learners. What this shows is that this is immediate. It is not provide us with a piece of paper that shows at some future date you will provide a meal. It says implement it in a way that provides a daily meal, not in a way that will provide a daily meal. And your leadership knows what we've referred to in our heads of argument, that when it comes to the right to a basic education, it is an immediately realizable right, which is not dependent on progressive realization, not dependent on available resources, but immediately realizable. And if the NSNP is part and parcel of the right of access to a basic education, we then say to your leadership that our learners friends should be directed to ensure that it is implemented to provide a daily meal. So that is in paragraph 5. Paragraph 6 is a declaration against the MECs, and the same with paragraph 7. But paragraph 8 is also important, because this is a direction, a structural order to the MECs, that they are ordered forthwith to implement the NSNP in their respective provinces in such a manner that it provides a daily meal to all qualifying learners, whether they are attending school or studying away from school as a result of the COVID-19 pandemic. So like paragraph 5, paragraph 8 is an immediate implementation to ensure that each and every learner receives their food, regardless of whether or not they have resumed classes. And so it's not a defense to argue that in some other future date, we put this case and we will give you the food. The fact is that the order requires the food to be provided today to everybody as soon as the order has been made. Once those two orders have been granted, which are crucial, paragraph 5 and paragraph 8, what we then ask for in paragraph 9 is further structural orders, which is in 5 days, they should then file a plan and a program, which will also be implemented without delay. And those must deal with the specific items in paragraph 9.1, 9.2, and 9.3. And then in paragraph 10, which also I need to spend a little bit of time on, we then say the minister should file reports with his court under oath and provide copies to the applicants every 15 days from the date of this order until the order is discharged. What those should deal with is they should set out the steps she has taken to give effect to the order, when she took such steps, what the results of those steps have been, what further steps she will take, and when she will take each such step. So again, the fact that they've given an answering affidavit containing a number of policies does not mean that this order is no longer necessary or is no longer appropriate. It is still appropriate for her to report to the court, because as we speak today, no food has been provided. And as we speak today, a declaration is still necessary. And as we speak today, a mandatory interdict in terms of paragraph 5 and 8 is still necessary. And that is why she must report to the court. Your Lordship remembers the case of Muelase, which was a land claims case at the Constitutional Court, where the Constitutional Court had to decide what to do about the failure of the Minister of Land Affairs to implement the land reform program, particularly for a vulnerable category of land claimants called labor tenants, where it was ultimately decided that the plans that the minister had put in place were simply inadequate. And it was necessary for a court to step in. In fact, not only necessary, it was mandatory for the court to step in, bearing in mind the unique vulnerability of labor tenants and bearing in mind the equivocation of the minister on paper. We have the exact same situation in this case. We have an extremely vulnerable category of learners who are poor and most likely African and Black, but where the state equivocates about whether they are entitled to these rights or not, at least on affidavit. And that then takes me to paragraph 11. That applies to the MECs, but the content is the same as paragraph 9. And then paragraph 12, that applies to MECs, but the content is then the same as paragraph 10. So the point of emphasis on the notice of motion is that in paragraph 5 and 8, we ask for immediate relief. Are we entitled to this? I've shown your leadership that under section 38, your leadership should grant an appropriate relief. Under section 172, your leadership should grant a supervisory relief. On the facts of this case, where we have the administrative chaos and confusion in the provinces, where we have deepening levels of hunger, Professor Seekins explains this as a colossal disaster. And he goes on to say what has happened is that as a result of the lockdown, because the lockdown has had an impact on availability of food, Professor Seekins says as a result of the lockdown, people have been driven to extreme poverty levels, and particularly children whose parents are unable to feed them. It is almost logical that this is what would happen. In those circumstances, is it appropriate then to grant a supervisory order? We would say not only appropriate, my lady, but in these circumstances, it is mandatory. It is the only remedy that will ultimately get the state to do something about it. So we have referred in our heads of argument to the authority. I don't know if your leadership has received it, but it is at footnote 87 for your leadership to have regard to. It's an article prepared by Kent Roach and one Mr. Jeff Badland. I don't know whether he's here or not, called Mandatory Relief and Supervisory Jurisdiction. When is it appropriate, just, and equitable? But it is an instructive learning for the circumstances in which a mandatory order would be appropriate. We've used those to develop the argument at paragraph 162 of the heads of argument. What we say there, for three primary reasons, judicial supervision is warranted in this case. Firstly, the department has played fast and loose with the facts. It misleadingly claims that it was always its intention to roll out the program to all learners when schools reopen. Yet the recordal of the minister's decision shows that she had decided against this rollout. And as a matter of fact, the NSNP was not rolled out to all learners when the schools reopened. It is only this application which appears to have brought about a change of plan. Your leadership has seen the various changes of attitude. At the beginning of this, the attitude was, we're going to roll out to everyone. And then at a later stage, they decided, no, we won't roll it out. And then at some other stage, they decided, well, it will only be those who have resumed classes. And then they said, well, it is going to be done with effect from the 22nd of June. And then you have this letter that is undisclosed, written by the Director General, sent to the provinces, which in fact is probably the true position of what was going on. In that letter, they say that they have received advice that this matter is in court and that they should make sure that by the 22nd, the program has been rolled out. Yet on the 23rd, Section 27 and Equal Education undertake this research in relation to what is actually happening on the ground, and they discover truly shocking accounts of how, even in relation to the committed 2 grades, there were still problems in the implementation. So the kind of playing fast and loose with the facts by the minister, rather in this case, by the Director General, should simply not be condoned. And the fact that on the ground, the program has not been reinstated. Then the second reason is that where you have a serious degree of violation, an egregious degree, here one struggles to find circumstances that could be worse. Children being driven to starvation by government policy that simply does not care. And then thirdly, the continued breach. The problem here, my lady, is not that they violated in March, or they violated on the 8th of June, or they violated on the 22nd. It's that as we speak today, that violation is continuing and it is getting entrenched. And so we have this scenario where large numbers of children are in fact being driven to hunger and starvation. And I already tried to show your leadership that there is chaos and confusion in the provinces. There is one thing that the minister, the DG says to the court, and there's another message that she is communicating to the provinces. And this is why the provinces do not know what to do. The Gauteng is told, implement this on the 22nd. But it is just impossible because the letter that says it must be implemented on the 22nd is sent in the afternoon of the 22nd. And that's why we have no clue today about what is the extent of the school nutrition program in schools. So when you actually look at the bigger picture of this, truly, the only way that the government can be brought into the frame of the constitution, which it has illegally taken itself out of, is through judicial supervision. So we have a scenario where judicial supervision is in fact not just a matter of choice, but it's become an imperative. There's a judgment that was delivered yesterday, One Nation Movement by Musa Maimane, where the entire thing was dismissed. And it was found that judicial supervision in any event would have been inappropriate. But your Lordship will find that the reason it was inappropriate is because on the facts in that case, there was no violation of the right at all. But the facts in this case simply cry out for the judiciary to step in to monitor the conduct of the government. One cannot eat a piece of paper. What is necessary is food on the table. So we have also referred to the hearsay evidence that we've asked for your leadership to admit. It's self-evident why it should be admitted. Many of the people we act for.
My lady, we will not object on the basis of inadmissibility. We don't take that point.
Oh, thank you. That is very generous of Mr. Ostes, and we appreciate that.
Thank you very much.
May then, in the exercise of a discretion under Section 3(1)(c) of the Law of Evidence Amendment Act of 1988, admit all of the hearsay that is contained in the founding and in the replying affidavit. So in those circumstances, we should get the relief in its entirety, together with costs, including the cost of 3 counsel. 3 counsel is specially warranted in this case. There was initially a denial of the right and a denial of the obligation. It seems to have been substantially neutralized in Mr. Oshazen's earlier pointing out, and this is why I am not going into Section 27 and I'm not going into Section 28. I'm focused only on Section 29, which seems to be the only remaining defense on the merits. So in those circumstances, we would ask your leadership to order not only that we should get costs, we should also get costs of 3 counsel. Thank you, my lady.
Thank you very much. Mr. Westhuizen, are you ready? Or I don't know if it would be convenient that we just adjourn for 5 minutes for perhaps a comfort break for everybody, and then I'll give you an opportunity.
Thank you. I would go for the comfort break, but I would also suggest, if it finds your approval, that the amicus curiae go first.
Yes,
because they, right. Although they are here as amicus, they support the relief. So,
I agree.
As it please you, my lady.
Okay. All right. We'll then have a 5-minute comfort break. All my clocks say different times, but I'm going to go on my cell phone. It says 11:39, so let's make it 11:40. So at 11:45, we'll be back.
Thank you, Melody.
Because we will just then adjourn.